The judge leaned forward, glanced at the prosecutor, and said 4 words that changed everything. Motion to suppress granted. The charge was driving under the influence. The evidence the state wanted to use, the officer's observations, the arrest, the entire basis for the case was now gone. All because of one decision my client made in the first 90 seconds of a traffic stop. He refused to perform field sobriety tests, not in a belligerent way, not by arguing, by using an exact set of words that I'm going to give you before this video is over. By the time you finish watching, you'll understand why that phrase is so powerful, when you can legally use it, and how it just might keep a routine stop from turning into a life-altering arrest. Let me take you back to the night it happened. This is the story of a traffic stop that looked ordinary, a broken tag light, a quiet suburban street, and how it fell apart for the prosecution the moment they tried to stretch a 2-minute equipment stop into a full-blown DUI investigation without the legal grounds to do it. And I'm telling you this story because most people have absolutely no idea that the officer leaning into their window right now is hoping they'll do the one thing that hands over all the reasonable suspicion he doesn't yet have. It's just after 11 on a Thursday body cam. Footage slightly grainy under streetlights shows a dark Honda Civic rolling past a strip mall. The officer's dash cam captures the traffic stop from the cruiser's perspective, red and blue lights washing over the rear glass. The officer's voice comes through the body-worn mic. Evening. The reason I stopped you is your tag. Light is out. License registration and proof of insurance. Please. Polite routine. My client, I'll call him Daniel, hands over the documents. His hands are steady. He doesn't fumble. He doesn't smell like a bar floor. The officer steps away to run his information, and for nearly 8 minutes, nothing happens. 8 minutes sitting in the driver's seat, engine off, waiting. Here's where the law splits from what most people assume. A traffic stop is a seizure under the Fourth Amendment. That means it has to be reasonable in both its initiation and its duration. The Supreme Court made this crystal clear in Rodriguez v. United States back in 2015. A stop prolonged beyond the time reasonably required to complete the mission of the stop violates the Constitution. That mission is tied to the original reason for the pullover. If you get stopped for a broken tag light, the mission is to address that tag light, run the license, write a warning or a citation, and let you go. The clock stops when the ticket's been handed over. Officers cannot drag it out to conduct an unrelated drug or DUI investigation unless they develop independent, reasonable suspicion that a different crime is afoot. When the officer returns to Daniel's window, he's already run the paperwork. Daniel has a clean license. No warrants, no prior DUI, nothing. The objective of the traffic stop is essentially complete, but instead of handing back the documents and giving a warning, the officer does what police are trained to do. He launches a conversational side mission. You headed home tonight, sir. Any alcohol in the car? How much have you had to drink this evening? These are not questions about the tag light. They are an attempt to build a DUI investigation on a foundation that doesn't yet exist. And this is where Liam did something most people don't. He recognized that he was being eased into a fishing expedition, and he declined to take the bait. Calmly, directly on camera, he didn't say, "I'm not answering that." He didn't get hostile. He didn't default to, "I do not consent to a search," because this wasn't about a search. He used words that addressed exactly what was happening at that moment. He looked at the officer and said, "Officer, I'm not going to perform any field sobriety tests. I'm not answering any questions without a lawyer. Am I free to go?" 3 sentences. One compound right built into a single memorable utterance. That sentence is the reason the judge suppressed everything that followed. Let's break down why that phrase is a legal fortress. The first piece, "I'm not going to perform any field sobriety tests," is a clear, unambiguous refusal to participate in voluntary roadside exercises. In virtually every jurisdiction in this country, standardized field sobriety tests. The horizontal gaze nystagmus, the walk and turn, the one-leg stand, are entirely voluntary. There is no law that compels you to stand on one leg on the side of a dark road and perform balance tricks for an officer who is already looking for a reason to arrest you. Breathalyzer statutes and implied consent laws apply to chemical testing, a breath, blood, or urine sample after a lawful arrest. Refusing field sobriety tests does not trigger an automatic license suspension the way refusing a post-arrest chemical test might in some states. That's a crucial distinction. Yet officers frequently frame it in a way that suggests you have no choice. They'll say, "I just need you to step out and do a few quick tests for me," in a tone that makes it sound mandatory. Daniel's refusal removed the officer's ability to gather the very clues, the subtle indicators of impairment. The slight sway, the missed heel-to-toe step that would have supplied the reasonable suspicion the officer was missing. The second piece, "I'm not answering any questions without a lawyer," is a simultaneous invocation of the Fifth Amendment right to silence and the Sixth Amendment right to counsel. Now, the Sixth Amendment right to counsel technically attaches once adversarial judicial proceedings have begun. So at a roadside stop, it's more of a preemptive request for an attorney. But combined with a clear refusal to answer questions, it unequivocally triggers the protections against compelled self-incrimination under Miranda v. Arizona, and the principle that once a suspect unambiguously invokes the right to remain silent or to have counsel present, questioning must cease. Now, at this stage of a traffic stop, a person is not in custody for Miranda purposes under Berkemer v. McCarty. So the officer isn't required to give Miranda warnings before roadside questioning. But the driver's statement still carries weight. It puts the officer on notice that the driver is asserting his rights. And, more importantly, it denies the officer the conversational inroads, the small talk, the admissions about having just one beer that later get used to build probable cause. Daniel didn't give the officer a single word about what had been doing that evening, how he felt, or what had to drink. Silence is not evidence of guilt. The Supreme Court has said that refusal to cooperate standing alone doesn't create reasonable suspicion. In Florida v. Bostic, the court noted that a refusal to cooperate without more does not furnish reasonable suspicion. So, when Daniel refused both in the tests and the questions, the officer was left exactly where he started, with a broken taglight and no articulable facts that Daniel was impaired. The third piece, "Am I free to go?" is a direct detention challenge. This transforms the encounter from a consensual conversation into a legally scrutinized seizure. If the officer says, "Yes, the stop is over," and Daniel drives away. If the officer says no, he is now affirmatively detaining Daniel, and that detention must be supported by reasonable suspicion of some crime beyond the taglight, which at that point had already been addressed. Daniel had answered the initial summons and produced his documents, and now was being kept from leaving. The question forces the officer to either articulate a legal basis for continued detention, one that can be challenged in court, or end the encounter. A lot of people get the order wrong, by the way. They'll ask, "Am I free to go?" before refusing the tests. Or they'll mix it with emotional pleading. The sequence matters. By first refusing the tests and the interrogation, Daniel made it clear he wasn't going to supply the missing evidence. Then, immediately, he challenged the basis for any further detention. He stripped the officer of his two most powerful tools, the suspect's own performance and the suspect's own words. What happened next on the body cam is instructive. The officer, clearly not expecting such a composed response, paused. Then he said, "Step out of the car anyway." He didn't answer the question. He didn't state a legal basis. Daniel didn't resist. He stepped out calmly and remained silent. The officer continued to ask him to perform tests, told him he could make this easy on himself, but Darian simply repeated, "I'm not answering questions without a lawyer. Am I free to go?" The officer eventually arrested him for DUI, based almost entirely on a claim that Daniel had glassy eyes and a strong odor of alcohol, both of which were contradicted by the earlier body cam footage that showed no visible impairment and no odor complaint during the initial interaction. The prosecution later tried to use the refusal itself as evidence of guilt, which is a tactic prosecutors often attempt. They argued that an innocent person would have just done the tests. The judge didn't buy it because the stop had already exceeded its lawful mission. Without reasonable suspicion, everything that happened after the point of unconstitutional prolongation had to be suppressed. The refusal to perform field sobriety tests couldn't be the bootstrap that created reasonable suspicion where none existed. The arrest fell apart. The legal reasoning here is built on a chain of protections that fit together like a puzzle. The Fourth Amendment, through Terry v. Ohio, allows an officer to briefly detain someone when there is reasonable, articulable suspicion of criminal activity. But that suspicion must exist at the moment the detention shifts from addressing the initial traffic infraction to investigating a new offense. In Rodriguez, the court rejected the government's argument that officers can add a few extra minutes of dog sniff or questioning time as a de minimis intrusion. A stop extended by even a few minutes without independent suspicion is unconstitutional. In Daniel's case, the officer had returned the documents. He had no valid reason to suspect impairment based on the original stop, and then launched a new line of questioning that went nowhere without the driver's cooperation. The officer's demands that Daniel step out and perform tests amounted to an additional seizure unsupported by reasonable suspicion. The judge applied the exclusionary rule, and the DUI charge simply vanished. The flip side of this, and the part that makes people nervous, is that refusing field sobriety tests can sometimes lead to an arrest anyway. A refusal doesn't automatically end the stop. An officer who already has reasonable suspicion of impairment based on driving behavior, an open container in plain view, bloodshot eyes, the odor of alcohol, slurred speech, and admission of drinking can still arrest you for DUI, even if you never set foot out of the car. But that's the point. If the officer already had those facts, the refusal doesn't hurt you anymore, and it denies the prosecution. The neatly packaged FST clues that are so difficult to challenge on video. And if the officer doesn't have those facts, no FST clues equals no extra evidence. The refusal prevents him from manufacturing them in front of the body cam. That's what Daniel's case exemplifies. The officer was fishing. The refusal forced him to try to justify an arrest with evidence he simply didn't have, and the body cam proved it. So when do you deploy those exact words? The phrase, "I'm not going to perform any field sobriety tests. I'm not answering any questions without a lawyer. Am I free to go?" is designed for the precise moment when the traffic stop has shifted from its original purpose into a DUI investigation, and you sense the officer is looking for reasons to escalate. Before you say it, you've already complied with the lawful orders of the stop. You pulled over safely. You provided your license, registration, and insurance. You haven't been argumentative. You're speaking in a calm, even tone. The words themselves aren't a magic spell. They're a legally significant declaration that preserves your rights and creates a clear record on camera. The key is to not answer for the preliminary probing questions. When the officer returns to your window and asks, "Have you been drinking? Have you been drinking tonight?" That's the pivot. That's the moment you deliver the phrase. If you've already admitted to a beer at dinner, you've handed over a piece of the puzzle. If you step out and start the heel-to-toe dance, you're building the probable cause case for them. By the time you stumble on the ninth step, probable cause complete, the stop is over and you're in handcuffs. Now, it's worth acknowledging the nuance around implied consent laws. Some states have statutes that say refusing to submit to a chemical test, breath, or blood after a lawful arrest will result in an administrative license suspension. That and intra-tests. That is separate from the roadside field tests. In those states, if you're arrested and the officer reads you an implied consent advisory, refusing the chemical test carries its own civil penalty, and your refusal can be introduced as evidence in a DUI trial. But that's a conversation you have after an arrest, in the booking room or at the station, not at the side of the road, with a flashlight in your eyes. The phrase I gave you is for the voluntary pre-arrest phase. It doesn't advise you to refuse a lawful chemical test after arrest. That's a whole different analysis. What it does is make it far less likely that you'll ever reach that arrest stage in the first place, if the officer doesn't already have solid grounds. And let's talk about body cams for a moment, because I always tell my clients that camera is your witness. In Daniel's case, the body cam showed the officer's calm initial demeanor. The absence of any impairment cues the refusal, delivered without confrontation, and the officer's decision to arrest anyway. The prosecution's entire case rested on assertions that were flatly contradicted by the footage. Without the camera, it would have been the officer's word against Daniel's, and prosecutors bank on juries, believing the uniform. With the camera, we had an objective third party. If you ever find yourself in this situation, remember that everything you do and say is being recorded. The best thing you can do is be as still and as silent as the recording itself, aside from invoking your rights clearly. If you take away one thing from this case, let it be this. A traffic stop is not an obligation to build the government's case for them. Not your job to incriminate. The officer has a job to do, but you have rights that exist precisely for moments when that job starts stretching beyond its legal limits. Knowing the exact words to use and the right sequence to use them turns a high-pressure, confusing encounter into a moment of clarity. And that clarity can be the difference between a dismissal and a conviction. The judge in Daniel's case looked at the body cam footage, looked at the prosecution, and said, "I don't see reasonable suspicion." Motion to suppress granted. Daniel walked out of that hearing room with no criminal record, no license suspension, no ignition interlock, and a very clear memory of what happens when you know the boundaries of a stop, and you state them plainly. Next time, I'll break down the one question every officer asks during a traffic stop that sounds like casual conversation, but is actually a carefully designed legal trap. And I'll give you the exact response that shuts it down without giving up anything.